Hello everyone. In this presentation, the rules pertaining to the applicability of the provisions of the Indian Penal Code will be explained. As we have already seen, the name of the code is the Indian Penal Code. Its date of operation is from 1st January 1862 and it will operate throughout the territory of India. A well-recognized principle of criminal jurisprudence is that the exercise of criminal jurisdiction depends upon the place where the offence is committed and not on the nationality or domicile of the offender. To apply the provisions of the code, it must be shown that the offence for which the accused is charged was committed within the territory of India. For the purpose of application of law, the territory of India includes not only its land, its internal waters such as rivers, lakes and canals, and territorial waters which extend up to 12 nautical miles, but also includes that portion of sea along its coast called maritime zone, which includes 24-mile contiguous zone, 200-mile exclusive economic zone, and a continental shelf up to continental margin or 200 nautical miles, whichever is greater. Therefore, any offence committed anywhere within the territory of India, as explained above, would attract the provisions of the code. Section 2 of the code imposes criminal liability for offences committed within India. It says that every person, irrespective of his nationality, rank, status, caste, color or creed, is liable for being punished under the code for an offence committed within India. The words every person include citizens, foreigners, a company, association or a body of persons incorporated or otherwise. A foreigner cannot plead ignorance of law. He cannot say that the act was not an offence in his country and he did not know that it was an offence in India. Criminal liability for an offence arises on the basis of laws applicable in the country where the offence is committed and not on the basis of laws applicable in the country to which the accused belongs. In the case of offences like cheating, which involves a number of elements, some of which do not require the physical presence of the accused, like deception, corporeal presence of the accused at the place of offence is not required for holding him liable for the offence, provided that all the elements of the offence occur within the territory of India. However, heads of sovereign states and their representatives such as ambassadors, high commissioners, diplomatic agents and UN representatives enjoy immunity against criminal prosecution under the Diplomatic Relations Convention Act 1972. The President of India and governors of states are exempt from criminal prosecution under Article 361 of the Constitution. While Section 2 provides for territorial operation, Sections 3 and 4 provide for extra-territorial operation. Section 3 gives criminal jurisdiction to the courts to try an offence committed by a person beyond the territory of India if he is subject to the Indian law. Example, if an Indian soldier commits murder in Nepal while on service, he is liable to be prosecuted for murder in India. Clause 1 of Section 4 extends the operation of the code to offences committed by a citizen of India in any place outside India, and Clause 2 of Section 4 to offences committed by any person on any ship or aircraft registered in India. The reason behind extending the operation of the code to offences committed outside India is that every sovereign nation has the power to regulate the conduct of its citizens irrespective of where they are. Where an Indian with a wife and 3 children in India marries an Irish woman in England, he can be prosecuted for bigamy under Section 494 IPC on his return to India. But if he was not a citizen at the time when the offence was committed, he cannot be tried in India for an offence committed outside and beyond India. If a foreigner, after committing a crime outside India, enters India, he may be sent back to the country where the offence was committed for trial. This can be done only when that country sends a proper requisition, and this requisition proceedings are called extradition proceedings governed by Indian Extradition Act. Extradition is a political act done in pursuance of agreement between countries and is not applicable to offences which are substantially political in nature. Section 3 and Clause 1 of Section 4 of IPC and Section 188 of Criminal Procedure Code empower local courts to take cognizance and try offences committed outside India. Clause 2 of Section 4 gives admiralty jurisdiction to Indian courts, that is, jurisdiction to try offences committed on high seas, as the high seas have been recognized as no man's territory. This jurisdiction extends to trying offences committed by Indians as well as foreigners on any ship or aircraft registered in India wherever it might be. This is because a ship or aircraft registered in India and flying the Indian flag is considered to be the territory of the country whose flag it flies. Admiralty jurisdiction extends to trying pirates also, because piracy is considered as an offence against all nations. Thus, the provisions of the Indian Penal Code are applicable to every offence committed within the territory of India, any offence committed by a citizen of India outside India, to any offence committed on foreign ships and aircrafts within Indian territory, and to any offence committed on Indian ship or aircraft wherever it may be. This in brief is about the operation of provisions of the Indian Penal Code. Thank you.